I was turning left and somebody completely sideswiped, hit tail end of my front right, and
where were they turning from?
From right there, this road right here, turning left, and I was turning left as well, and I had the right of way. I had the right.
Did you have a green light, a red light?
I had a green light. I had a green steady light, and I was coming from that way. Turned left.
So you were on
and
Country
they
Club,
me.
or you were on?
I was on 25, or is that 31? I'm sorry.
Okay, you were on 25 and
Yes.
north or south?
That was south, correct?
Towards St. Charles would be south. Okay.
I was heading to turn left this way.
On the Country Club?
And as soon as I did, they swiped my right front end.
Okay, and where were they coming from?
Right on this road. They were
They
going
were
left
on
that way.
Country Club?
Yes, sir.
Turning left.
Correct.
So you were turning left on the Country Club from
So I was
southbound
coming
25.
from this way. Coming
So
left
you
side
weren't.
of this road.
This is Country Club, though.
Okay.
So give me a second here.
Okay, I'm sorry. I'm so frazzled. I finally just got on the phone with police officer. I'm like shaking up. So I was coming from.
Yep. Hold on.
Okay.
This is Route 25.
1310 from Trecum.
Go ahead.
I just heard County give out the attempt to locate again. Can you confirm that this is the white Jeep they're looking for?
Give me
Or
1
looking for?
second. 28 for this Jeep is C. Charles B. Boy 33907. Charles Boy 33907. This will be the other vehicle for the accident.
And to be honest with you, I think I may need an ambulance once we're done with this all because I'm having an anxiety attack. But anyway.
Do you want an ambulance?
I would like one, yes, please.
Okay.
Ryan Joseph Hresil was born on October 2, 1998, in Elgin, Illinois, into a family that would later describe him as a person of extraordinary intelligence, warmth, and drive. He graduated from Central High School in Burlington, served 6 years in the Army National Guard, and worked at Water Services Company in Elgin, where he also applied his skills as a diesel engine mechanic. He was engaged. His fiancée was named Carly. He was a passionate poker player, by most accounts a workaholic, a friend to everyone he encountered, and a man with a deep passion for riding motorcycles and being surrounded by his closest circle. That last passion, motorcycles, would become the axis around which the final chapter of his 27 years would turn, in a manner so sudden, so violent, and so entirely preventable that the weight of it would fill a Kane County courtroom just days later, with dozens of grieving people demanding to understand how a Wednesday night in early April could end with a young man's life extinguished at a suburban intersection he had every right to cross safely. His mother, Susan Hresil, would later reveal that Ryan had just gotten the motorcycle the day before the crash. 24 hours. That is the span of time between the acquisition of a machine he loved and the moment that machine became the centerpiece of a fatal collision investigation. The timeline is not incidental, it is the kind of biographical detail that crystallizes just how randomly and catastrophically a life can be redirected by another person's choices. Ryan Hresil did not take a risk by riding that night. He exercised a legal right on a public road, at a well-lit intersection, in the suburban Kane County city of St. Charles, Illinois, a community of approximately 33,000 residents located 35 miles west of Chicago. What met him at that intersection was not chance, not fate, and not mechanical failure. What met him there, according to every piece of evidence that investigators would subsequently assemble, was a driver who was legally drunk, potentially further impaired by a controlled substance, and operating a sport utility vehicle with the kind of reckless disregard for the rules of the road that Illinois law has specifically criminalized at the felony level. On Wednesday, April 1, 2026, at approximately 10:52 p.m., the St. Charles Police and Fire Departments were dispatched to the intersection of Country Club Road and North 5th Avenue for a traffic crash involving injuries. That intersection is not obscure or difficult to navigate. North 5th Avenue is also designated as Route 25, a state highway corridor that runs through the Kane County suburbs and carries significant commuter and recreational traffic through St. Charles. Country Club Road bisects it at a standard controlled intersection, the kind of crossing that drivers navigate every day using nothing more than basic spatial awareness, a clear understanding of traffic signals, and the physiological capacity to perceive oncoming vehicles and make accurate speed-distance judgments. At nearly 11 o'clock on a Wednesday night, traffic volume would be reduced relative to peak hours and visibility conditions in early April in northern Illinois, while not the height of summer clarity, would not inherently obscure a motorcycle traveling on a state highway. What investigators would determine, and what Assistant Kane County State's Attorney Katie Flanagan would later articulate with precision in open court, was that an SUV executed a left-hand turn at that intersection directly into the path of Ryan Hresil's oncoming motorcycle. Authorities say the crash occurred about 10:50 p.m. on 5th Avenue, Route 25, at Country Club Road, when Mroz's SUV turned left in front of a motorcycle driven by Hresil. A left-hand turn is one of the most consistently dangerous maneuvers in motor vehicle operation, not because it is inherently complicated, but because it requires a turning driver to yield to oncoming traffic, to judge the speed and distance of approaching vehicles, and to execute the turn only when a safe gap in traffic exists. That calculation demands cognitive precision, reaction time, and accurate visual processing. It demands, in short, a sober and attentive mind. What the evidence would show is that the driver of the SUV, later identified as Morgan C. Mroz, a 29-year-old woman from West Chicago, Illinois, did not possess that sobriety at the moment she initiated that turn. It was reported at the time that an SUV and a motorcycle were involved in the crash, and a witness on scene reported that the driver of the involved SUV may have fled the scene. That witness account, transmitted through dispatch channels to incoming patrol units, immediately transformed the nature of the call from a standard injury accident response to a potential hit-and-run involving a fleeing driver. Officers and firefighters arriving at the scene of Country Club Road and North 5th Avenue found the aftermath of a high-impact collision, and in the middle of it, a critically injured young man who had been violently displaced from his motorcycle by a force that the human body is not built to survive without exceptional luck or protective circumstance. When officers and firefighters arrived, they found the injured motorcyclist and immediately began providing medical aid. The Kane County Accident Reconstruction Team worked the scene while first responders took the rider to Del Nor. The deployment of the Accident Reconstruction Team is itself a significant institutional signal. These are not generalist patrol officers. They are specialists trained in the physics of vehicular collisions, the mathematics of impact angles, the measurement of skid marks and gouge patterns in asphalt, the precise documentation of debris fields, the photogrammetric mapping of final rest positions, and the backward engineering of a collision sequence from its physical aftermath to its kinematic origins. Their presence at Country Club Road and North 5th Avenue that night meant that investigators were already treating this crash as a serious criminal event, not merely a traffic incident. The physical evidence they documented would ultimately serve as the forensic foundation for multiple felony charges. Ryan Hresil was transported to Northwestern Medicine Del Nor Hospital in Geneva, the closest major trauma-capable facility in that corridor of Kane County. He was found critically injured and transported to Northwestern Medicine Del Nor Hospital, where he was later pronounced dead. Ryan J. Hresil, age 27, of Elgin, passed April 2, 2026, as a result of a motorcycle accident. He died in the early hours of April 2, his injuries a direct consequence of the collision that investigators were already working to reconstruct, document, and assign legal responsibility for. While paramedics were still working to stabilize Hresil in the back of an ambulance, and while the accident reconstruction team was beginning its systematic measurement of the crash scene, St. Charles patrol officers were executing a simultaneous priority, locating the SUV that the witness had reported fleeing the scene. St. Charles police located the SUV and the driver nearby. The proximity is legally and analytically significant. A driver who flees a collision scene and is found nearby has not escaped, geographically or evidentially. The short distance between the crash site and the location where Mroz and her vehicle were found means that investigators had an essentially intact evidence scene to work with. The vehicle had not traveled far enough to be washed, restaged, or materially altered. Whatever damage it sustained in the collision with Hresil's motorcycle, whatever substances were inside it, and whatever physical and physiological state its driver was in, all of that remained accessible to law enforcement. Kane County records indicated Mroz's residency on Campton Trail Road in St. Charles, a detail that adds another layer of geographic context. Mroz was not a stranger to the area. She was operating a vehicle in a community where she had residential ties, navigating roads that, by geography, she would have been broadly familiar with. This is not the profile of a confused out-of-towner who misjudged an unfamiliar intersection. This is the profile of a local driver who made a left-hand turn at a known crossing with catastrophically impaired judgment. The investigation that followed the vehicle stop was systematic and methodical. Officers began gathering physical and physiological evidence almost immediately upon making contact with Mroz. What they found would build, layer by layer, into one of the most comprehensive impaired driving criminal cases to emerge from Kane County in recent years. The first and most immediately telling evidentiary discovery did not require laboratory analysis. Police found a sandwich bag containing a white powdery substance and several rolled-up dollar bills with that substance on them. A preliminary test showed the powder contained cocaine. The sandwich bag and the rolled dollar bills are not ambiguous artifacts. Their combination is a well-established pattern associated with cocaine use, the bag as a storage vessel, the rolled currency as an improvised inhalation tool. Their presence inside the vehicle that had just killed Ryan Hresil placed a controlled substance at the center of the criminal investigation from its very first hours. Officers also found several empty cans of an alcoholic seltzer in the vehicle. The empty cans matter not as proof of intoxication in isolation. The mere presence of empty alcohol containers in a vehicle does not legally establish that the driver consumed them while driving, but as part of a constellation of physical evidence that, taken together, paints a specific picture of what was happening inside that SUV in the period preceding the collision. Empty cans, a cocaine-positive substance, a driver who had just executed a catastrophically mistimed left-hand turn at a state highway intersection and then driven away from the dying man her vehicle had struck, each element compounds the others into a narrative that investigators and prosecutors would come to characterize as a pattern of dangerous, willful, and criminally reckless conduct. The chemical test results would become the numerical core of that narrative.
You end up down here.
When I got sideswiped and T-boned, it completely threw my car off. My tire got flat, my front right end tire, and totally veered me off into here. I was holding on for dear life, just about to scream. Next thing you know, I did call 911, the dispatcher, and she said, just stay put, they're going to find you. Thank God you guys did.
Did you come to a stop at the intersection?
I did.
Okay, then how'd you end up over here?
Again, when I turned left, I got my right end to completely swipe.
Yep, and you came to a stop?
I was at a stop before I turned.
Okay, so after you...
Once I turned, she completely slammed into me, and then my tire flattened, and
Did you come to a complete stop after the accident happened?
I do not know.
Okay, so you were coming from a friend's house in South Elgin? You were south on 25, making a left hand on a country club. And then you were sideswiped by an SUV that was turning from country club onto 25.
That's correct.
And they were making a left. So that doesn't make a whole lot of sense. If that car is making a left and you're making a left, it would have been a front end damage or it would have been your driver's side. So how's your passenger side get hit?
I mean, I would say it was more of a T-bone than a sideswipe, but...
But if the T-bone would have happened, it would have been on your driver's side.
I know, but I started turning in and she kept going, and we were in the intersection when that happened.
Which would have put your driver's side against her front end.
If you say so, but I know what happened, so.
Okay. And nobody else was in the vehicle when the accident occurred? Okay. And where are you headed to?
Home. And my mom's gonna freak out if I don't get her.
How old are you?
I'm 28.
28. Okay. Hold tight real quick, ma'am.
Assistant Kane County State's Attorney Katie Flanagan said Monday that Mroz refused to take a breath test at the scene, but a blood test done several hours later at a hospital indicated she had a blood alcohol content of 0.13. The legal limit is 0.08. The refusal to submit to a roadside breath test is itself legally consequential in Illinois. Under the Illinois Vehicle Code, a driver who operates a vehicle on a public highway is deemed to have given implied consent to chemical testing when lawfully requested by law enforcement following a lawful arrest or reasonable articulable suspicion of DUI. Refusing a breath test triggers an automatic statutory summary suspension of driving privileges under Illinois law. But beyond the administrative consequence, the refusal created a tactical delay between the crash and the definitive chemical measurement of Mroz's blood alcohol level. That delay matters because blood alcohol content is not a static figure. The human body processes alcohol at a relatively predictable rate, typically between 0.01 and 0.02% per hour, varying by individual physiology, body weight, food consumption, and metabolic factors. A blood test administered hours after the refusal of a roadside breath test will generally yield a lower BAC reading than would have been obtained immediately after the crash. This is the standard retrograde extrapolation problem in DUI litigation, and it cuts consistently in one direction. If a driver's blood alcohol measured 0.13 several hours after the crash, the BAC at the actual moment of impact was almost certainly higher. The exact differential depends on variables that toxicologists calculate based on individual metabolism and the timeline between last drink and blood draw, but the directional logic is straightforward and well established in forensic toxicology. A reading of 0.13, already 62.5% above the legal limit of 0.08, becomes an even more alarming figure when subjected to retrograde analysis toward the moment of impact at 10:52 p.m. on April 1. The refusal to submit to the breath test must also be evaluated as a behavioral data point in its own right. A driver who is not impaired has no rational incentive to refuse a breath test. A clean or legal limit result would exculpate rather than inculpate. Refusal is overwhelmingly associated in both the research literature and in prosecutorial experience with the knowledge of impairment, a driver's calculated decision that the breath test result would be more damaging to their legal position than the administrative and legal consequences of refusal. When combined with the subsequent 0.13 blood test result, the cocaine-positive substance found inside the vehicle, and the fact that the driver had already physically fled the crash scene before law enforcement arrived, the refusal pattern assembles into something that investigators and prosecutors found deeply compelling. Illinois courts have long recognized that the combination of alcohol and stimulants like cocaine presents a particularly dangerous pharmacological profile for drivers. Alcohol depresses the central nervous system, it impairs motor coordination, slows reaction time, degrades spatial judgment, and distorts risk perception. Cocaine, as a stimulant, does not counteract these impairments in any reliable or predictable way. Instead, it creates a false subjective sense of competence and alertness that can actually intensify the danger by masking the physical reality of impairment from the driver themselves. A driver who is drunk and using cocaine does not become more capable. They become a driver with degraded neurological function who believes, or can be led by the drug's effects to believe, that their function is adequate. The result is a person at the wheel of a multi-ton vehicle who cannot accurately judge the speed and distance of an oncoming motorcycle, who initiates a left-hand turn at a state highway intersection as that motorcycle approaches, and who creates a collision that no amount of defensive skill on the motorcyclist's part can prevent. The physics of what happened at Country Club Road and North 5th Avenue in the seconds after Mroz initiated that left turn are brutally simple. A sport utility vehicle making a left-hand cut across an oncoming lane presents its lateral profile to any vehicle traveling in that lane. A motorcycle approaching in the oncoming lane has a combination of factors working against survivability in that scenario. The low frontal profile of a motorcycle means that a turning SUV driver with impaired visual processing may not register it as quickly or accurately as a larger vehicle. The mass differential between an SUV and a motorcycle is enormous, meaning that in the collision itself, the motorcycle and its rider absorb a catastrophically disproportionate share of the impact energy. And the exposed position of a motorcycle rider, even one wearing protective gear, means that the transfer of that kinetic energy to the human body is direct and devastating. Ryan Hresil's injuries were consistent with exactly this collision geometry, and the accident reconstruction team's documentation of the scene would help establish the mechanism of impact with the specificity that felony prosecutions require. The question of Mroz's post-crash behavior, specifically, the act of leaving the scene, is addressed directly by one of the 4 major felony charges approved by the Kane County State's Attorney's Office. Following an investigation into the crash, the Kane County State's Attorney's Office charged Mroz with multiple felonies: failure to report a crash resulting in death, aggravated driving under the influence resulting in death, reckless homicide, and possession of a controlled substance, as well as several traffic citations. The charge of failure to report a crash involving death is not a minor procedural violation. Under Illinois law, any driver involved in a crash that results in injury or death is legally required to remain at the scene, render reasonable assistance to the injured, and report the crash to law enforcement. Leaving the scene of a fatal crash is a Class 1 felony in Illinois, carrying a sentencing range of 4 to 15 years in prison, with mandatory minimum sentencing provisions that reflect the legislature's determination that this act represents a profound violation of both legal duty and human decency. The act of driving away from Ryan Hresil as he lay critically injured in the road is not a panicked split-second mistake, it is a sustained decision, maintained over the distance between the crash site and where Mroz was ultimately located, and it is a decision that denied Hresil any possibility of additional assistance from the person most directly responsible for his condition. Mroz was charged with 1 felony count of failure to report a crash, 2 felony counts of aggravated DUI causing death, a felony count of reckless homicide, a felony count of possession of a controlled substance, and 4 additional traffic citations. The 2 separate counts of aggravated DUI causing death are a reflection of the dual basis structure of Illinois DUI law. Prosecutors can charge a defendant under multiple subsections of the DUI statute simultaneously when multiple aggravating circumstances are present. In this case, the 0.13 BAC establishes impairment by alcohol, and the cocaine discovery, once confirmed by laboratory analysis, would support a separate count based on impairment by a controlled substance. Each count of aggravated DUI causing death in Illinois is a Class 2 felony carrying a mandatory minimum of 3 years in prison and a maximum of 14 years, with the sentencing judge required to consider the death of the victim as a major aggravating factor. The reckless homicide charge, a Class 3 felony in Illinois under 720 ILCS 5E9-3, specifically addresses the manner in which Hresil's death was caused, the operation of a motor vehicle in a reckless manner that creates a strong probability of great bodily harm or death. The charge does not require proof of intent to kill, it requires proof that the manner of driving represented a conscious disregard of a substantial and unjustifiable risk. An intoxicated driver making an unprotected left turn at a state highway intersection in front of an oncoming motorcycle satisfies that standard with room to spare. Mroz had a prior DUI conviction from 2019. Mroz had a prior DUI conviction from a 2019 incident in Campton Hills. The significance of this prior conviction cannot be overstated in the context of both the criminal charges and the detention hearing that would follow. A prior DUI conviction transforms the legal landscape in multiple ways. First, it elevates the criminal classification of a subsequent DUI offense under Illinois law. A second DUI is a Class A misdemeanor if no aggravating factors are present, but aggravated DUI causing death carries the same enhanced penalty structure regardless of prior history, so the prior conviction's most direct legal impact in this case is as a sentencing aggravator and as an indicator of pattern conduct. Second, and perhaps more critically in the context of the detention hearing, the prior conviction demolishes any argument that April 1, 2026, represented an isolated aberration, a single catastrophic error in judgment by an otherwise law-abiding driver. The 2019 DUI conviction from Campton Hills establishes that Mroz had already, years earlier, been formally processed through the criminal justice system for driving under the influence, had already received whatever consequences the court imposed at that time, likely including mandatory treatment programming, license suspension, and judicial admonishments about the danger of drunk driving, and had retained none of that deterrent effect by the night of April 1, 2026. The sequence of events following Mroz's arrest moved through the Kane County justice system with the procedural velocity that serious felony cases demand. Mroz was detained pre-trial in the Kane County Adult Justice Center, where she was booked April 2, 2026 at 8:04 a.m. The booking occurred in the early morning hours of the day after the crash, hours before Ryan Hresil's family had even received final confirmation from Northwestern Medicine Delnor Hospital that he had died. The bureaucratic processing of the person responsible for his death was underway even as the medical team delivered the news to Jerry and Susan Hresil that their son was gone. A West Chicago woman accused of driving under the influence and causing a crash that killed a motorcyclist last week in St. Charles would remain in jail while awaiting trial, a Kane County judge ruled Monday. The detention hearing, held on Monday, April 6, 2026, 5 days after the crash and 4 days after Hresil's death was officially recorded, was the legal proceeding at which Illinois courts determine, under the framework established by the Safety Act and Illinois' pretrial release law, whether a defendant poses a sufficient danger to the community or flight risk to justify continued pretrial detention without monetary bail. Illinois abolished the cash bail system as of September 2023, replacing it with a judicial risk assessment framework that requires prosecutors to demonstrate by clear and convincing evidence that no condition or combination of conditions of release would adequately protect the community or ensure the defendant's appearance in court. Assistant Kane County State's Attorney Katie Flanagan argued that case before the judge on April 6. The factual record she had to work with was extraordinarily strong. A defendant with a prior DUI conviction who had, on the night of April 1, operated a vehicle with a blood alcohol content more than 60% above the legal limit, with what preliminary testing indicated was cocaine in her vehicle, who had executed a left-hand turn at a state highway intersection that killed a 27-year-old man, who had then driven away from the scene of the death rather than render aid or report the crash. This is not a close call under any reasonable application of the pretrial detention standard. Flanagan presented the 0.13 BAC figure, the cocaine discovery, the prior 2019 Campton Hills DUI conviction, the empty alcoholic seltzer cans, and the flight from the scene as interlocking elements of a pattern that demonstrated not merely that Mroz had made a catastrophic error once, but that she represented a documented and ongoing danger to the driving public. Releasing Mroz on electronic home monitoring and having her wear an alcohol monitor or ordering her to undergo daily breath testing would not be adequate to prevent her from drinking and driving again, the court determined. That judicial conclusion is analytically significant. Electronic monitoring and sobriety conditions are the standard toolkit of pretrial supervision. They are the conditions that courts routinely impose to balance the presumption of innocence and the right to liberty against the need to protect the community. The judge's determination that even those conditions were insufficient in Mroz's case reflects a judicial assessment of the severity and pattern nature of the conduct, the inadequacy of non-custodial supervision to address the specific danger she presented, and the weight of the evidence against her. Several dozen people attended Monday's court hearing, including Hresil's parents and representatives from ABATE, a motorcyclist safety and rights advocacy group. The presence of ABATE, the American Brotherhood aimed towards education, an organization that has fought for decades for the legal rights and safety of motorcyclists on public roads, at Morgan Mroz's detention hearing was a statement. It was the motorcyclist community asserting its collective presence, its collective grief, and its collective demand that the justice system treat the death of Ryan Hresil with the weight it deserved. Motorcyclists are disproportionately the victims of left-turn crashes precisely because of the visibility and size differential between motorcycles and larger vehicles, and the ABATE members who filled seats in that Kane County courtroom understood this dynamic viscerally and personally. Jerry and Susan Hresil were there as well. The parents of a man who had survived 6 years of Army National Guard service, who had built a career as both a water services professional and a diesel mechanic, who had proposed to the woman he loved, who had acquired a motorcycle the day before he died. They sat in that courtroom and heard Katie Flanagan lay out the evidence that their son's killer had been legally drunk, likely cocaine impaired, had a prior DUI conviction, had fled the scene, and had been found nearby with empty alcohol cans and a cocaine-positive white powder in a sandwich bag in her vehicle. They heard the judge rule that Morgan Mroz would remain in custody. And they absorbed the particular, devastating arithmetic of it all. Ryan's mother, Susan Hresil, said he had just gotten the motorcycle the day before the crash. One day. The motorcycle was 24 hours old in Ryan Hresil's possession when Morgan Mroz turned left at Route 25 and Country Club Road and ended his life. The investigation into the crash was still ongoing at the time of the detention hearing, with the Kane County Accident Reconstruction Team's full analysis and the laboratory confirmation of the white powder's cocaine composition still working through their respective processing pipelines. The charges presented: failure to report a crash resulting in death, 2 counts of aggravated DUI causing death, reckless homicide, and possession of a controlled substance, represented the state's attorney's assessment of the evidence as it stood in the first days of the investigation, and the judge found that evidence sufficient to justify continued detention. The Illinois criminal justice system's trajectory from this point is one of methodical legal process, pre-trial hearings, discovery exchanges between prosecution and defense, laboratory confirmations, expert witness designations, and ultimately either a negotiated disposition or a trial. The charges Mroz faces carry, in aggregate, the potential for decades of incarceration. The 2 aggravated DUI causing death charges alone carry mandatory minimums and maximums that, if imposed consecutively, would represent a substantial prison term. Reckless homicide adds its own sentencing range. The failure to report charge adds more. And the possession of a controlled substance charge, though the least severe of the group, adds yet another felony count to the stack that the Kane County State's Attorney's Office will carry into whatever courtroom proceeding ultimately resolves this case. Ryan J. Hresil, age 27, of Elgin, passed April 2, 2026. The son of Jerry and Susan Hresil, Ryan served in the Army Reserve. He was a passionate poker player and pretty much a workaholic. He was a friend to everyone he met and would do anything for them. He had a passion for riding his motorcycle and being surrounded by his friends. Besides his parents, he is survived by his 2 brothers, Kyle and Benjamin, and his fiancée, Carly. Visitation was held April 10 at Yours Funeral Home, 405 East Main Street in St. Charles. Burial was at 11 a.m. on Saturday, April 11 at Plato Center Cemetery in Plato Center. The gap between those 2 dates, April 1 and April 11, 10 days, from the night a young man got on a motorcycle he had owned for 24 hours to the morning his family carried him to his rest at Plato Center Cemetery, is the human dimension of what investigators document in crash reports, what prosecutors quantify in blood alcohol readings, and what judges weigh in pretrial detention hearings. The Kane County criminal justice system will continue to process the case of People v. Mroz through its procedural stages, generating docket entries and court dates and legal arguments. The accident reconstruction team's report will be finalized. The laboratory's cocaine analysis will be submitted. Katie Flanagan and her colleagues at the Kane County State's Attorney's Office will build and refine the prosecution's case. Defense counsel will challenge what can be challenged and negotiate what can be negotiated. The machinery of justice will grind forward. What it cannot do, what no legal proceeding, no matter how thorough or how just its outcome, can accomplish, is restore the 24 hours between the day Ryan Hresil first rode his motorcycle and the night at Country Club Road and North 5th Avenue where that ride ended. It cannot restore to Susan and Jerry Hresil the son who served his country, built a career with his hands, and loved his fiancée enough to ask her to share his life. It cannot restore to Carly the future she was promised. It cannot restore to Kyle and Benjamin their brother. What the legal system can do, what Assistant State's Attorney Katie Flanagan argued it must do, and what the Kane County judge agreed it should do on April 6, 2026, is ensure that the weight of what happened on that April night is carried forward into accountability, that the charges are pressed with the full force of the evidence, and that Morgan C. Mroz remains in custody to answer for every one of them. These charges against Mroz are not proof of guilt. She is presumed innocent and is entitled to a fair trial in which it is the state's burden to prove guilt beyond a reasonable doubt. That is the architecture of American criminal justice, and it is the framework within which every fact documented here, the 0.13 BAC, the cocaine-positive powder, the prior 2019 Campton Hills DUI conviction, the empty alcoholic seltzer cans, the left-hand turn at Route 25 and Country Club Road, the flight from the scene, the witness account, the accident reconstruction team's documentation, the detention hearing ruling, will eventually be tested, argued, and adjudicated. The Kane County courts will determine the legal verdict. The physical evidence, the chemical evidence, the witness evidence, and the behavioral evidence are already part of the record. Ryan Hresil was 27 years old. He had a motorcycle for one day. He had a fiancée, 2 brothers, parents who described him as highly intelligent and very well loved, a community of friends, a career, and a future that was cancelled at an intersection in St. Charles, Illinois, at 10:52 p.m. on April 1, 2026, by a driver who should not have been behind the wheel of anything that night, and who, according to every piece of evidence collected, knew exactly what she had done when she drove away.